Every Tuesday, we do bring in immigration updates live from Houston, Texas, from 5 p.m. Central Time to 6 p.m. We take live questions. Along with me is my business partner, Stephen Brown. Stephen, what do we have today to discuss?
Yeah, we're going to be giving updates on Birthright Citizenship. Lots of action last week, as we've kind of predicted. It's going to continue to move quick, and we'll talk about where that update is and what it means for everybody. We're going to talk about the surge in deportation funding for ICE under the One Big Beautiful Bill and what it means for legal non-immigrants. We're going to talk about a new visa integrity fee under the One Big Beautiful Bill. And then we're going to talk about the EB1A consultancies and their false guarantees and kind of what steps you should take if you're kind of caught in their program.
So let's discuss about the birthright citizenship, Stephen, that you and Emily were being telling that, okay, it's going to be nationwide. The same thing, at least you predicted. It seems that based on the class action suit, which you have sued a couple of times and won in the class action suit yourself as a lawyer. It seems that the New Hampshire court has certified the class action, and they did apply the class action to everybody in the entire United States who are going to be born in until the Supreme Court decides what they want to do about it, that they should be given the U.S. They should be given the birth certificates, they should be given the U.S. passports, and they should be given the U.S. citizenships. That's what the New Hampshire court. Of course, we know that the Trump administration is appealing its decision. Now, there are a lot of disagreements, Stephen, whether people, especially before the New Hampshire court case came in, whether people should move to the blue states or not. Of course, you have been a firm advocate that, okay, the court is going to come in the favor of a class action. Looks like you won. Maybe I did not win, at least my argument. But anyway, coming to the point, there were a lot of people who want to move to the blue states instead of red states. But right now, that may or may not be that advantage right now, at least right now, as it stands today. If a person is born on August 1st, they will be given a U.S. citizenship. They will be given a passport at this point of time. Can you update more on that, Stephen?
Yeah. So, if we go back to the CASA opinion from the Supreme Court, striking down nationwide injunctions, the Supreme Court still kept the door open to a couple ways that nationwide relief can still be granted. Really, what the crux of the CASA decision was, and I don't want to bore everybody with a kind of law school nerd answer here, but it really is about what is complete relief for the parties. And when you have one plaintiff suing in the Northern District of Texas Amarillo Division, like the state of Texas like to do against Joe Biden, is nationwide relief appropriate for complete relief? What the Supreme Court discussed in the opinion is that there are ways that nationwide relief can be appropriate. One is class certification, where we have a class action under Federal Rule of Civil Procedure 23. We also could have, when states are plaintiffs, we might need nationwide relief in order to have complete relief, because we can't end up with a situation where, you're a plaintiff because you live in New Jersey, or you're a citizen because you live in New Jersey, but not Texas. Like, that's not how our system should work. And then, you could have complete relief under the Administrative Procedure Act, which is how we sue a lot of times. But let's talk about where we are here. The court, right after the CASA decision, all of these groups moved to update their lawsuits to be class actions, broadly defined their classes, and really to a point where it gets everybody, and then move for injunctive relief for those the classes that were certified. Now, Not surprisingly, they're appealing. They are appealing this now. I will say, they're. I don't know if their goal would be to, appeal based off of kind of the broadness of the party. I did talk with a former government attorney who said it's got to be something where they take up the merits because they're so intertwined. Um, and so I do think right now. So where are we today, Rahul? Instead of me boring everybody with kind of my law school
So,
first semester,
well, yeah, I know you get into this too
um,
much
it
technicality
is
because
enjoyed.
you are the class action lawyer.
Yeah, I
Um,
just I find it very
yeah,
interesting from a nerd
I,
level, but you
yeah,
know
I
the
I claim
it
to
is
be I
it's
claim
enjoyed,
to
right?
yeah, I claim to be that my best resume is that I've been a client before I became an immigration lawyer.
Yeah,
So for
yeah,
me,
no,
the client question is, my child is getting born in Texas right now, and he's going to be born, and he or she's going to be born in August 20th.
and
What should I move to blue state right now?
I don't think there's any reason to do so. Right now, you are part of your child, potential child, is part of this class. It is enjoined. The government is stop.
You told the people that the Trump administration is appealing this decision.
Mhm.
What if they get the approval there in their favor?
I think if it goes in the government's favor, we'll kind of be back to where we were after the CASA decision, where we're going to get more guidance on how this is going to go. And how this is going to impact. But I don't think we end up anywhere where you're a citizen based off of where your child is born, statewise. That Texas versus California, for example. I don't think we're going to end there. There's no way from our system of government and our basic tenets of citizenship that we could do that.
Okay. As we were advocating at one point of time, I was telling people that, yeah, probably if you would have gone to blue states, it would have been advantage. Right now, I'm definitely backtracking it on that particular part, but I want people to closely observe. At this point of time, as Stephen has pointed out, that no matter where the child is born, at this point of time, even after July 27th, as it stands today, that is July 15th, 2025, 5 p.m., 5:09 p.m., looks like they will be given U.S. citizenship. But please keep tuned to our
And
channel. If there is any changes, we'll let you know.
real quick, and I want to address, a YouTube commenter there, three things in life, like, hey, kid being born in a different state that's not part of the injunction. So there's really, as far as I know, and I'm sure there's more, there's three big cases. You have one up in New Hampshire, which is Barbara et al. That's a pseudonym. You have the CASA decision case, which is a kind of immigrants' rights group, and then you have um, a case led by numerous states attorneys general, and not every state. I think it's 20 something states. Obviously, the state of Texas is not part of that. The decision that came out of the District of New Hampshire in the Barbara et al. V. Trump case. Again, this is a nationwide relief for pretty much anybody that's impacted now and in the future of the executive order. Now, maybe there's debate about whether that's appropriate or not. But right now, this doesn't matter what state you're in. You're part of this class, unless you choose to opt out, which I don't think you will. You are part of this class automatically, and it's enjoined no matter what state. This is not the case involving states, and I'm sure they're going to get their own injunction here this week. I imagine the CASA cases, if not already. And so, yeah, it doesn't matter which state, U.S. state, the kid is born.
Right, let's go to the next topic. The next topic would be that, well, we got more funding right now to the immigration. Now, which immigration department is a different issue, but is that good for the non-immigrants who are legally abiding and staying in the United States, paying taxes, abiding by every immigration law, or is it not good for them?
I think what we're going to see is this is the Trump administration trying to make good on their promise, what they view as a mandate to increase immigration enforcement. Now, Rahul, you and I've already seen an increase of, um, I'm going to call them what they are. They're frivolous notices to appear because they're trying to, pump up numbers and data points to make, the headlines or to make certain people in DC happy that more NTAs are being issued. But as you get more funding, they are going to be able to increase enforcement, increase, potential worksite raids. I don't think that's a major deal for most of our clients. But I-9s, maybe we will see more NTA stuff like that. I mean, ICE is going to be the largest law, the most $160 billion budget is more than any law enforcement agency in the United States, as far as I am aware. So that's a lot.
So definitely, this is not good news. More stricter FDNS, stricter things. This budget, what they have, is definitely higher than the FBI budget, which is tasked to do a lot of different tasks, including the terrorist and other things, though, that they need to protect. But this seems to be very, these people, the ICE will definitely focus on enforcing the immigration laws, but at the same time, they are going to hamper the people who are legally staying in the United States, make their life miserable. Now, what is this new additional fees that you wrote an article today, Stephen?
Yeah, this was something I thought was underlooked in the one big beautiful bill that was just signed into law July 4th, is that there are a number of immigration related fees that are put in by Congress, authorized by Congress. Now, let me start by saying none of these are implemented yet. We will probably have to see something, Federal Register notices or policies, whatever they're going to be, to implement it. But they're really the big one, I think, for most of our clients. I say big. I think, you told me it's not as crazy, but I want people to be aware is this visa integrity fee that is added to every U.S. non-immigrant visa. So when you go to apply for your visa, you pay, your money for the DS 160 to get the visa and all that. On top of that, now you're going to be paying this $250 visa integrity fee every time the non-immigrant visa is issued. So H1s, L1s, O's, F1s, B visas. So it's 250, all non-immigrants. There's no waiver to it. It's for each visa. Now, in the law, there is this idea of it being refunded to you
Oh,
if
come
you,
on.
yeah, right. Well, you'll get there. If you abide by all the terms, you depart when you're supposed to, or you legally, extend your status in the U.S. We don't know how that's going to work. I mean, I wrote in the article that everybody should treat this as non-refundable upfront cost until we really see it actually in action where people are getting $250 checks from the government. Again, that's how the law is written. We'll see how it's actually implemented. But it is something for people to be aware of. I mean, other fees, there's a $24 I-94 fee, mostly for border crossing. ESTA is increased. And then not really kind of our client based, but TPS is increased. There's now asylum application fees, humanitarian parole, and increase in immigration court costs. So again, 250 per visa stamp. I just don't want people to be shocked, when they go for their visa and then be like, Stephen never said anything about this. Well, now I did.
Um, I want to also address, we got a lot of complaints from the people about this EB1 consultants. I mean, these are not lawyers, but these people are, initially we thought these people are just giving the information out on the YouTube. Then later on we learned that they're actually practicing law according to us. And they're practicing law, they're advising people on legal advices. They are, it's, it's like, I telling that, okay, I got cancer, I got treatment like this, that's probably maybe okay. But then advising people that if you get a cancer, you need to take this medicine. Now that is crossing the lines, though, because that is where I am entering into the medical field, which I don't have a license for. And I see a lot of these consultants doing it on, especially for the EB1, they started making money. One of the way that they found out is that they got these kind of Globee awards, and where people will pay $300 to get the awards and present them as the internationally acclaimed awards. And we saw them getting the green cards for some of the people, and then they started getting a lot of people. And of course, the USCIS has found out right now that a lot of these things are faked up articles. In fact, I had some fake consultation with this EB1 guaranteed getting the green card kind of people. And they said, I don't have the articles. They said they're going to publish it for me. I mean, it's very surprising the way they said. Now, I don't see any lawyer doing that at all. That is completely not ethical. And we have a law license that does not allow us to do write articles on behalf of doctorate level articles. Definitely not. These people are writing articles, they are publishing, and they are faking the things. They're also getting the citations. In fact, we have seen some notice of intent to revoke on some of the cases where people have got citations of 500 citations in the just past in a 3 weeks time, and it looks like they're all faked up, according to what we have studied. So if you get defrauded by these people, the best solution for you is, you can approach the unauthorized practice of law committee. Each state bar has it. Some of the state bars have it. In Texas, it is a state Supreme Court, though, that appoints some of the lawyers to help people prosecute. In fact, I was been there in the unauthorized practice of law committee for a period of 3 to 4 years, appointed by the Texas Supreme Court to bring to the notice of the people who are practicing law without license. So each state has their own things. You find out where these people are located at. You can complain to that particular unauthorized practice of law committee, or you can even send a complaint to the Texas, the state bar, whichever bar they are, whichever state they are in, because these people are practicing without license. They will direct you where to complain if the person is practicing law without license. Now, of course, ALA, USCIS have put up a lot of notifications on this, that these people, they call it notarios, in the words, without law license, they practicing law. So if you find any of these EB1 consultants that have been faked up and have taken the money, you can complain to an unauthorized practice of law committee. That's the best source that you can do, so that these people can be shut off, and then probably you can get money refunded from these people.
Yeah,
Anything
and
else, Joe?
yeah, just real quick on that. We have seen these. I mean, USCIS is digging into these, and I think they're seeing trends and maybe certain things that are causing them to dig into it. We've seen notices of intent to deny, so this is definitely on USCIS's radar now. At the same time, if you have a legitimate profile that fits EB1, like don't be scared. They're not going after people who are genuine applications. They're going after uh, the people that are using these services to game the system. So just keep that in mind.
Okay, and let's go to the question and answers. Ryan. The question that comes from Manisha is that, what about the notice to appear? That's a question that she has. We are noticing a lot of notice to appear. If you do get the notice to appear, we strongly recommend that you do need to contact an immigration lawyer immediately. The good news is that when Emily we has contacted the USCIS, they did responded saying they want proofs that the clients that we are speaking about have legal status, so that she can inform. We did put out all the information. We are contacting the USCIS, at least the 10 people that contacted us, to completely take off the notice to appear. I don't know if it's going to work out, whether USCIS is going to do it or not. We don't know, but that's one thing that you can, because once the notice to appear comes in, though, unless the government takes it back and says that it has taken it back, the way to approach, you can't just leave the country. You have to get the permission of the court to leave the country. You have to take the voluntary departure. And some of the times the hearings are backlogged to such long time. One of the client that I had consultation today got a notice to appear in 2028, which is 3 years from now. There are limitations that once the notice to appear, the USCIS may adjudicate the pending applications or may refer to the immigration court to get adjudicated these applications. So definitely it's a serious matter. And one other thing, Stephen, that I want to point out, I had a consultation today where the person has filed a non-proton case. What is a non-proton case? Is that it's an established regulation that if the person goes out of status, they can if that out of status is not because of their mistake, it's of somebody else's mistake, which was beyond their control, they can request the USCIS to grant the status back. That is called non-protonc. Stephen, it doesn't look good under the Trump administration right now, even to file a non-protonc. You know why? We got a notice to appear for the case where somebody filed a non-protonc. Now, of course, you have done a lot of non-protonc cases, Stephen, before. What do you advise clients right now to file a non-protonc? Wait for the notice to appear, or probably travel outside the country to get the stamping?
I mean, I'd probably travel. I mean, the notice, the non-protonc regulation does allow them to exercise discretion. It is completely in DHS's discretion to grant it or not. I don't think they're going to look to exercise discretion in the favor of immigrants who have overstayed or violated their status, whether it's through no fault of their own. No, I think there might be some obscene circumstances that might be worth looking at, but at the same time, I mean, it's not even like the first Trump administration. I mean, they're being a lot different from them. So if you are thinking about filing an NTA and maybe have the option to leave, the non-protonc, and you have the option to leave before you get an NTA, I'd probably leave and fight another day.
Another one. The first question was from Manisha. This question was from Manish. He has an arrest for DUI, which the case was later dismissed. He has an advance parole. He wants to travel to Canada. There are a couple of things I want you to be careful. Canada has some restrictions for the people who have a DUI to travel into their country. So I want you to check the Canadian law first, though. Even though you may have gotten a visa, for example, a visiting visa to go to Canada, if you got the DUI afterwards, there may be some issues. We are not Canadian lawyers, so please discuss on the Canadian front. As far as the US is concerned, though, if you keep the documentation, and Manish is telling that he's an advanced parole, if you keep the documentation of the DUI and you have an advanced parole, this is only for advanced parole, not for the automatic visa revalidation guys, advanced parole people. Now, you can travel. We do not see any problem since the case is already dismissed. Keep the documentation. You can travel and come back. As far as the US is concerned, we don't see as a problem.
Question from AJ on YouTube. We did downgrade to EB3, upgrade to EB2. EB3 is about to be current. Do we need to downgrade again? So I think this is going to be an interesting one because Rahul and I probably have different advice on this. I have litigated a ton of 485 delays like your situation where you go downgrade, upgrade, now you need a downgrade. My advice and what has worked in our lawsuits when people have become current again, and maybe wait a little bit to see if it gets picked up, is to say, look, we've been approved in EB3 and EB2. We're current under EB3. My client, the plaintiff just wants his green card. We really don't care what category it's in. But we're eligible for both. I'll also have you send in a tub letter before we file the lawsuit so we can say, hey, we did it. How do these cases work out? I've had some cases where it gets through smooth and it just, hey, issue the immigrant visa. I've had some where the U.S. attorney says, look, they just want another written letter confirming None of my clients have objected to that or a 485J if we need to, but I think it gets that tree shaken loose because, sometimes even if you file that transfer underlying basis right now, it might just go, into a black hole where we don't really know. When we have litigation involved, we might um, be able to have success in getting some good guidance, speak to some adults in the room. Yeah.
Very interesting question from Sri Revant from YouTube. He has a question for the people whose civil system visa got revoked. These are almost like 5 to 10,000 people that got their service. They had some or the other interaction with the legal info, the police people at one or other point of time. He was asking, do you see any people getting an RFE and OPT or STEM extension? What are the ways to succeed in this administration? The answer is yes. We are noticing some RFEs on the OPT and STEM extension. Emily has written a very good article on it. I would refer you to rnlawgroup.com, go to the blog, and it's recently written. What she has advised is that when responding to the RFE, though, you have to say that present all the documentation of the criminal that the case has been disposed of. And if there is anything, like, for example, if let's say you've been arrested for DUI and you are being continuously attending the AAA, this is kind of where people get and what is that? AA,
It's like counseling. It's like
yeah,
group
it's a
counseling.
group counseling. Even though it is recommended only for 5 hours, you are continuously attending every week, for example. That's probably is an indication that you're doing very good on that particular front. And you can present that in evidence. Look, I've been now rectified. I'm now a new person. I don't have the propensity to commit that kind of crime, which I got involved previously. So it's better to present a lot of different things, affidavits showing that you have a nice job and you've been performing very good from your colleagues and all those things. So please read that article in rnlawgroup.com. And for those people who are listening to us, we strongly recommend that you subscribe to our newsletter so that we post almost like 4 to 5 articles every week. And you need to be aware of these things if you are on a non-immigrant visa here in the United States and you are staying in the United States. It's better to subscribe because we give the updated information. So these kind of things you'll get updated. So definitely, Sri Revan Chaudhary, we recommend that you read that article which Emily has written. It has a very good idea what you can do.
I have one caveat to that advice, Rahul. If you were in one of my lawsuits on Sevis for the Sevis litigation, reach out to me because we have information in our settlements. We've had two of those come across for our clients that were in those lawsuits that had settlements related to their Sevis, and the government got them reinstated. So I think you need to put together a good response for sure. But it's also, I don't know. I don't know why they're still trying to mess with the student visa program. I mean, I do, but they just be careful with that. Don't just send in the court documents without providing kind of those good things as well. Abhishek got an RFE, Rahul, on H-1B for wet signature on I-129. Does it mean it's denied? This is something I've seen pop up every once in a while. So, during COVID and now kind of implemented since then, USCIS will take scans of wet ink signatures, but it has to be an original wet ink signature that is scanned in. It can't just be a digital Adobe, DocuSign, e-signature, whatever. I've heard rumors of a couple of these RFEs. I don't know why people are getting them. I think I would just provide the wet ink signed I-129 and be like, sorry, here it is. I don't know, if they wanted to reject it, they could have. We've seen those rejections from people before. So I think you can respond to that.
Silpa has this question about whether the child has to come for 12th grade here in the United States, or can she complete in USA, in India, and come here, and the daughter is a US citizen. As far as the immigration is concerned, it doesn't matter whether the child completes her 12th grade in India or USA. Now, personally, what is better? I don't know. It's up to you. You can get advice from somebody else. For immigration, since the child is a US citizen, absolutely not a problem. I just want to also tell people that there are some US citizens who are settled in India, and even if they have children born in India at this point of time, even if the Trump's executive order goes through, though, their children also will get the US citizenship directly. Now, let me tell you again, though. If a US citizen is residing in India and that person has a child in India, the child will get a citizenship. It is not an automatic citizenship. You have to take the birth certificate. You have to prove the documentation. This is the child of a US citizen. You can request a passport in the consulate. You can get it. So as far as your child coming for 12th grade, it's up to you, Shilpa, whether the child wants to come. As far as the immigration law is concerned, she's fine. Either way.
Question here on YouTube. Individual on H-1B, engaged to a U.S. citizen. They work about 100 miles apart, stay together a few days a month, because otherwise they've got to work. Once they get married and file for the I-130 and the 485, should we move in together and travel the 100 miles to work each day? So really, what you're going to want to do is show that you have a bona fide marriage, okay? And yes, generally speaking, spouses live together, generally speaking, but that's not always the case. I mean, I've known people that have, my father-in-law has worked in China before, it's possible. So what you'd want to do is, are you guys holding yourselves out to be married? You dated ahead of time, you got engaged, you celebrated your wedding, however that looks to you. And then, do you have bills? Do you have each other on the mortgage, the banks, the insurance, whatever it might be? Living separately might raise a question, but I don't think it's an instantaneous denial. And I think you can put together evidence that's like, look, we have a genuine marriage, because again, that is the question: is this a marriage for marriage purposes, or is it a marriage for a green card? The second is frowned upon, but again, you guys can live apart. So it just, how do you otherwise prove that you guys are really married?
What I normally do is I put both addresses for one of the couple, saying that one, let's say, for example, one person is living in New Jersey, one person is living in Boston. I do put both addresses, that this person is living in New Jersey and also in Boston, and then do file it. As long as the marriage is genuine, everything is genuine, we don't see much problems of the immigration at all for them to get the green card. I have a question for you, Stephen, which I think so I know the answer, but you are the litigation guy. Um, you know that the people, 5 to 10,000 people who got their service terminated and their visa got revoked. Is there a chance that we can take them to the court and get the visa reactivated back? This question is coming from Israq Alam from YouTube.
There are groups looking into that. We are looking to clean something up for our plaintiffs that went with us early on. We are hoping to do something for them here soon. I know there's other groups as well that are bringing one as well. What I'm not sure on, truthfully, is how much we'll get the visa back versus setting aside the revocation, so that way you don't have the negative impacts of the revocation. I do think there's ways to get the visa reinstated, but if it came down to, hey, if the Department of State says there is no procedure at all to do this, but what we can do is say, you don't have to disclose it, you don't have to mark yes on the I-485, the DS-160, the 260. I'm okay with that too, and we're not going to use it in a negative light. Like, I am cool with that too. Again, our goal, would be to set that aside. So it is happening. Just hang tight on that. Question. Let's see. I saw one here. Abdul asked, green card holder, but my I-130 petition for my wife and child are taking forever. Any help, please? So this is potentially, and I'm happy to have a conversation offline. I don't know if your priority date would be current if under the F2A, F2B categories, but I know USCIS has historically held the I-130s, especially for children, separately and slowed them down intentionally. And it's good that they do. Now, Rahul's probably like, why, everybody's thinking like Stephen sues all the time for delays. Why is it good for the I-130 to be slow for the child? Because of the backlogs in the family-based immigration, by allowing the I-130 to be pending until your priority date becomes current, it protects the child for purposes of the Child Status Protection Act. So that way, once the I-130 is approved and the visa becomes immediately available, you can subtract all the time the I-130 is pending. So let's take in a hypothetical. If you filed today, July 15th, 2025, and it takes 10 years for your priority date for F2B to become current for the child, your child, let's say, is 20 today. Now, when they get current and immediately available, they'll be 30. They're aged out. But because the I-130 took 10 years, you subtract that once the visa is available, and they'll be protected under the Child Status Protection Act. So I know it's frustrating. I get it, but it's also designed to be helpful.
SHW from YouTube has this question. There is some error in the EAD and it's been sent for correction. Am I automatically eligible for the auto extension? So if you're speaking about, are you speaking about H4 EAD automatic extension, or are you speaking about EAD extensions under the adjustment of status though? Under the adjustment of status, if the EAD, you already filed the EAD before the expiration, though, you definitely are eligible for the auto extension. For the H4, definitely if the H4 is already extended, then you are eligible for the auto extension, even if USCIS is taking time to correct the mistakes done on the correct the mistakes done on the EAD.
And there are provisions in the I-9 manual that allow them to use what are clearly, typographical errors. So have your employer look into that. Pratik asks, downgrade in 2020, priority dates May 20th, 2013. Should I file for litigation for EB3 as it's current? Happy to have that conversation. We are in the final quarter of the fiscal year. It is a good time to sue if you are current, but we are also getting to where visas might become unavailable. And so, if you reach out, I do 485 litigation. Happy to set up a call with you to discuss pros, cons, or otherwise.
Ankit has this question. I don't know whether he filed the 485 under EB2 or EB3 though. If, Ankit, you have an approval with company A on EB, and you have EB2 and EB3 approval with company A, and if you're working with company B right now and you file the adjustment of status with company A, the company B does not have to file either EB2 or EB3. They can use company A's EB3 approval and file an I-485J and request the USCIS to adjudicate under the EB3 application. Absolutely, they can do that. No problem with it. Now, if you never had EB3, and now you want company B, never had EB3 with any company, and now you want company B to request the US to adjudicate your application EB3, definitely you need company B to file a fresh labor and I-140 to get an I-140 approved in EB3 to request under EB3.
Question from Neil that I actually see quite a lot, and it's a misconception from the EB1C category. Can an H1B holder uh, apply for the EB1C category after spending a year in a foreign subsidiary? Yes. The common misconception is that you have to be on L1A in order to qualify for EB1C. Look, it is the most common route because they're twin sisters here between EB1A or EB1C and L1. But I have done, there's no requirement that you be in the US number one. There's no requirement that you be in L1 number two. And you could do it with someone who was on a TN, on an H1B, whatever, as long as they meet the qualifications for the EB1C, meaning they have worked for at least 1 year abroad in a managerial role for a qualifying foreign entity. And so again, your immigration status is irrelevant as long as you meet the EB1 category requirements.
Ramesh has his H-1B extension filed, but he received an I-140 approval right now. Can he attach the I-140 right now and request 3-year extension for the existing application? You can try, but most probably you won't be successful. You must have the I-140 approval at the time of filing the application, which you didn't have it. And especially if the application has already been filed, they're requested for 1 year, and now you're requesting for 3 years. Most probably they won't. That is, but you can try. I mean, there's nothing wrong in trying.
I've tried it because there's you'll get the RFE about the extension beyond the 6 years, and I've tried it. There's nothing wrong with trying it. I can say it does not work more often than it works. But the way I address those RFEs is, hey, we have the I-140 now. But if you don't want to care about that, here's how I qualify for the 1 year extension or the recapture or whatever. There's no reason not to try it. Worst case, you're going to get what you are entitled to anyway.
A question from YouTube. I've been asked a question with regards to what's going on the biometrics for the people who are filing I-140 and the people who are filing the extension. This is only for the people who ever had any interaction with the police at any point of time where they've been detained, arrested, or been charged with any crime. Yes, they are still requesting people to come to the biometrics. Now, if the crime is a petty things, though, then definitely things are normal. And for DUI also, we haven't seen any problem. But if there is anything like a major crime or which is like domestic violence or DUI where there was a bodily injury or something other related major crimes, definitely we want you to contact your immigration lawyer because we want you to take a memorandum and keep it ready. And probably at the time when you respond to the RFE, you may want to respond giving all the details why you should still be given the extension or the I-140 approval.
Question on YouTube is actually a pretty interesting one, Rahul. How do you answer the DS-160 question about a visa denial? Previously had a 221G, but then I got it stamped while the 221G was pending with another company and entered the US. Do I answer yes or no? So this is what makes this interesting. No one views a 221G as a visa denial, except the law. The statute 221G is a refusal of a visa. And so my recommendation would be to put yes, because it was refused. And then when you go, you get the chance to explain, was issued a 221G, later got visa approved. I have never seen people have issues by doing that. I think it's better than saying no and then thinking you're misrepresenting something. So again, no one really treats a 221G as a refusal, but it is a refusal.
Satish Ram has this question. Can the US citizens live permanently in India? Will that cause any problem for the US citizenship? Absolutely no problem, none whatsoever at all. I also get this question that, am I eligible for Social Security and can I get the Social Security amount paid while I am in India after I reach my certain age? Absolutely, you can. No problem, none whatsoever at all. There are some countries where, if you live in those countries, that you may not be able to get the Social Security. Those countries, if I last time I checked, was North Korea, Iran. These are the two countries I know. Previously, Iraq was also listed, but it's no longer right now. It's only Iran and North Korea that I remember. There may be some other countries I don't know, but India definitely is not in that list.
Uh, Sarvesh asks a good question on YouTube. Received an RFE for an I-140. Request proof that the employer can pay the salary mentioned on the perm labor certification. Is this common with this administration? How long does it take to adjudicate? We have not seen a change because of this administration. This is an ability to pay RFE. Really, this is a paperwork exam, right? Maybe the company didn't submit tax returns and you're not working with them. Maybe the tax returns don't show the right number. Maybe you're not making that salary now. This is not an uncommon request for evidence. Trump administration, Biden, Obama, it's very common. There are a lot of good ways that good attorneys like Ryan Wilk in our office have developed strategies, to get to show ability to pay. Um, but it's not, this isn't some Trump gotchaism.
Ashwin has this question that if the passport visa is, sorry, if the passport is only valid for the next 5 months, can we still go for visa stamping, which we are requesting stamping for 3 years? The answer is absolutely you can. You will still get the passport stamping for the next 3 years. If you're eligible for the stamping, you will, just because your passport is expiring. But one thing I want you to be careful is that when you enter into United States with that passport, which is expiring in 5 months, they may only give an I-94, even though, let's say, for example, your visa is approved from July 2025 to May 2028. And when your enter and your visa, your passport is expiring on December 31st, 2025. When you enter into the country, though, they may give I-94 validity only until December 31st, 2025. In that case, you have to rectify file an extension after that, or with the same passport visa stamping and get a new passport, of course, and travel outside the country before December 31st, 2025. And they will then give an I-94 until 2028. So that needs to be corrected. But at this point of time, temporarily, for your wife and child, even if it's expiring in 5 months, they will get the full 3 years of the H4 stamping that you're requesting, Ashwin.
Nerval asks a question on YouTube. If you get a medical RFE for an I-485 for an approved I-140 EB-1A, would you still have interview for the adjustment of status? It's possible, Nerval, but I would say it's not likely. I mean, typically, if your visa is immediately available, it's current, you have the approved I-140, and they send an RFE just for the medical, most of the time I see those cases, they get approved pretty quickly after the medical RFE is received. So can they still call you for an interview? Sure, that's completely within their discretion, but I don't think it's common. That's also not to say, anything would be wrong if you do get called in.
A small suggestion came that for Social Security, the citizens have to go once in a year to sign. Now, there is a difference between a supplemental Social Security and Social Security, though. For the supplemental Social Security, you have to stay in United States. There is an absence period, I think so, about 29 days at the maximum that you can be outside the country. That is supplemental, not a Social Security benefit. So for Social Security benefits, there is no need to come to the Social Security office once in a year. I've had so many people that I know, they do get the Social Security without going to Social Security office and signing every year once.
Question about the visa bulletin and EB-1A. So EB-1 moving ahead. So let me just throw some numbers out there, Rahul. We got new USCIS statistics on July 1st. Emily ran through some of these numbers. So let's just kind of go off of what she said here to you and I. There are about 48,000 EB2 and EB3 I-485s pending from India with priority dates before 2015. So that's about what she takes about 8 years to kind of move forward to clear out that backlog, about 3 years just to get through the 2013 cases. For EB1, there are 15,000 EB1 India I-485s pending with priority dates before 2023. They get about 7 to 10,000 visas each year. So that's already meaning next year's already accounted for. So she kind of thought about 3 to 4 years that the visa bulletin would stay behind for EB1. I have not checked her math on that, but she's a lot better with numbers than I am.
Question from Lucky Lucky. If the child who is moving on to F1 visa, and on F1 visa, he gets either a summer work internships or he gets a work permit where he works, can that child be included in the 485 application when the priority date becomes current and the child is under 21? So absolutely the child can be included. If the child has worked legally in United States on F1 and the child meets the definition of the under 21, because you know, Lucky, what the Child Service Protection Act is, even though the child was been employed on F1, since the child is your child and the priority date is current for you, can file the adjustment of status. Absolutely not a bar that the child has worked on a legal permit.
Naveen asked this question, and it might be a topic you and I need to do separately. H-1B was revoked after the employer withdrew the petition following a notice of intent to revoke. Am I eligible for the 60-day grace period? So it doesn't sound like you would, because there was a revocation, the notice of intent to revoke. Maybe you were in the 60 days if you're I-94, but this is also where we're seeing those NTAs pop up here when the company withdraws. So just be very cautious and make a decision very quickly. I hate telling people not to wait the whole 60 days. But right now we're seeing those NTAs come pretty quickly, Rahul.
Yeah, previously we were advising that they could, but right now what we are noticing is that with the NTAs coming very quickly, so we may want you to hurry up and file some non-immigrant status.
Sevis terminated, reinstated. Do you know anyone with who got an APT approved and got an EAD with a misdemeanor record? I'm trying to think of what my two that I had emailed on to the government attorneys. I think one did have a conviction. The other was a dismissed ticket. Rahul mentioned earlier, Emily Newman wrote a really good article on our website about how to respond to those RFEs when they come about. You're going to want to submit the court documents, as well as what's happening is USCIS is saying we have discretion over all EADs. Because of this, we're thinking about not exercising our discretion. We're going to deny your EAD, provide the court documents, and explain why we should exercise our discretion. So why should give them reasons why you should be given your OPT.
It's not that everybody who civis has been terminated, and visa has been revoked are getting the RFEs, but I would say that a good number of them are getting RFEs.
Yeah, I've got a pretty good ear to the ground with our lawsuits that we had, and I saw one today that got approved with, filed for STEM OPT July 8th with premium, and it was approved yesterday without any RFE. And that was someone who, again, was part of our lawsuit because their status was terminated because of a criminal record.
Mandeep is asking the question that is F1 is expiring in September 23, 2025. I don't know what F1 means. Does it mean visa stamping? Does it mean STEM extension? I don't know. Assuming it's a STEM extension, which is expiring on September 23rd, They get an automatic extension until it's called cap gap. You're allowed. And if the H1 is still pending, now the cap gap is extended, if I'm not mistaken, until about April of 2000 of next year, which is April of 2026. So definitely you can still continue working based on the cap gap if the H1B has been filed with change of status. Now, when you're saying F1 visa ends, I don't know, visa stamping does not have any meaning. It's only if he's saying STEM OPT. If the STEM OPT is expiring in September 23rd, definitely you have automatic cap gap extension. I'm sure it's about April or March of 2026. You can continue working.
Um, Question here: can we help with the process of moving from H4 to F1? Yeah, absolutely. We do those quite regularly. Definitely something we can help out with. Somebody had asked, I can't find it now. They had asked, H1B was approved, but H4 is still pending. EAD is expiring in September. What would you do in this situation? So, we've done videos before, and what Rahul calls the margarita switch. Margarita visa going to Mexico, coming back in. We can also always litigate these H4 EAD delays, depending on the set of circumstances that you have.
Vash has this question, on a H1B, can I be a passive investor? That means that you are not actively participating in day-to-day activities. You are not involved in the management of the company. And the companies in India, yeah, I mean, you can be a passive investor in US companies. You can be a passive investor in Indian companies. You can be a passive investor in, I don't know, in the companies that are in Mars. I don't know if they're,
Not marijuana companies.
yeah, Mars. I said Mars. Yeah. Thank you for correcting me. Yes, anything which involves a marijuana, definitely, whether it's India, anywhere, don't. You have to check with the immigration lawyer and the criminal lawyer before you do. Even if some people says it's legal, it doesn't become legal. Absolutely, that's not. But if you're investing in a legitimate business, absolutely not a problem.
Sina asked a really good question. I'm currently on O1A and seek to apply for EB1A. Can you please suggest the odds if the evidence could be repeated, or would any extra evidence be needed? So, O1A and EB1A are twin sisters. They're not identical, but they're twin sisters. The criteria you have to prove up is the same. Two things make this a few things make this a little interesting. Number one, you have a new petition, right? There's not deference to your O1 when applying for your EB1A. They're going to look at it completely fresh. We're in a different administration, and so keep that in mind. That it could be that, hey, now they don't like your evidence. Okay. Number two, you do have to prove for an EB1A. We have this Kazarian two-step, and so there's under this court opinion Kazarian, there's a policy memo that they conduct, basically two-part tests to EB1As. Like, do you meet the regulatory criteria? So you've met, the line items, and maybe you prove up all of them. Okay. But even if you have all of the regulatory criteria, step two is this final merits decision that is subject to really subjective scrutiny. What makes you in the final merits? Are you top of your field? And so what I would do if I was an O1 visa holder applying for an EB1A is show not only the evidence I have, but what evidence have I done since then? Maybe I've had 10 more patents. Maybe I've had more awards. Go through and freshen it up a little bit, because again, that Kazarian second step, truthfully, is where most EB1A denials happen. Raul, I think, is they could show, hey, I met these criteria, and then the officer says, I'm going to deny it on final merits.
Vijay Rai has this question. This question is coming that, can a guy who worked on H-1B can get the Social Security benefits. He didn't receive a green card in USA. He doesn't have a US citizenship. Now he moved back to India. The answer is clearly yes. And surprisingly, the answer is yes. Now, of course, you must have worked for 10 years. That's 40 credit hours that they call. In short, I would say if you have worked for 10 years in USA and you have moved to India and you reach the age, I think so between 62 and 67, depending on when you're going to retire, you will be eligible for Social Security benefits. Absolutely not a problem. I have had some people who have contacted me. I told them to apply. They did apply. They sent an email back that they're getting the money and no problem with it at all. That's a very surprising. A lot of people don't understand it. So especially if you want to move back to your home country and if you're contemplating it, probably complete the 10 years because you will be getting the benefits though. Anything else, Steven?
No, I'm good. And again, look, I feel like every day we're chatting about something new, Rahul. Just a reminder to folks, Rahul does a daily Zoom call. Emily and I do a weekly podcast. But we also, as things develop, we've done plenty of live sessions. So as Rahul said earlier, subscribe to our newsletter, subscribe to our YouTube. Doesn't cost you anything. And you can get some valuable information that might be critical to your current immigration journey.
Thank you very much for tuning.